going to give you are some general principles that I would often see litigants overlook, often to their detriment. Small claims is up to $10,000 in California unless you are a corporation. So it isn't really small potatoes, all right? Small claims compared to multi-million-dollar litigation suits, but $10,000 or anything close to that is not a small amount of money. So take this seriously, prepare and over-prepare to the extent that you can. You rarely will ever lose in life for over-preparing, but you will often lose by doing the opposite. So first, your evidence needs to tell the story. You are there to summarize and guide the story to the judge. And your evidence should be what flows and leads the story along. Not, in my opinion, or it was my belief that it was a simple narrative corroborated by the evidence, which I'll give you an example of in a moment. Next, you may have been taught by your school's writing instructor to always build up towards the conclusion. You know, I even was taught, don't be so conclusory, meaning don't just emphasize the conclusion. You got to build the narrative. Well, that is not what you want to do in small claims. That is in fact the opposite of what you should be doing in small claims court. And in case the reason for that is not obvious, the judge or the commissioner, sometimes a pro tem, is not there to be your counselor, not there to be your therapist. They are there to get as many of the items off the docket as early as possible so they and the clerks can get on with their day, either go to lunch or go home for dinner. They don't want to hear you talk about how long you've known each other and you've gone on vacations together and they named their son after you. None of that matters. You need to start with the conclusion and then substantiate it. So, example, what did the defendant do wrong? Well, you can start with the defendant didn't pay me back the $2,500 that the defendant and I negotiated into last year. We have a written agreement, which you'll see, Your Honor, is Exhibit A. It's dated when the defendant received the money. There's the acknowledgement in the letter that they did receive $2,500. The defendant paid me $100 and then stopped payment after that. I am suing for $2,400 plus interest, plus the filing fee, plus the service fee. And then the judge will pick it apart. They'll ask you and they'll ask the other party some questions to see, well, this doesn't line up. Wait a minute, both of these things can't be true, so which one of you is lying? It's going to be important for you to overcome the burden if you are the plaintiff, which means you have to prevail by a 51% margin or better. It's about the lowest standard for any kind of a civil proceeding, let alone criminal, of course. So this is the lowest bar for the person bringing the suit to overcome. And you can easily tip the scale in your favor if you have a legitimate case by just doing some basic preparations. So what often happens is it just comes down to the verbal agreement. And in how's the judge supposed to tell, well, one of you said you did, the other one said you didn't, so one of you is telling me the truth, therefore the other one is not. But when both of you have the same amount of evidence or lack of the evidence, then it's just your word against the defendant's word. And in that case, you probably shouldn't prevail if you're a plaintiff. That is why you need to bring in evidence in the form of exhibits. And you can't just dump everything on the court, because then you're going to impair your chances by burying your best points underneath a sea of mud. Give the judge the crux of the matter in the most compelling argument, substantiated by the most credible documentation or witness testimony or in-person witness that you can. Now, another thing is hearsay. All right, hearsay is almost always prohibited outside of small claims in most civil trials, most criminal trials, but California small claims has much more relaxed standards for small claims hearing, understandably, because these are in pro per litigants. So with hearsay, the judge can consider it. But if you want to maximize your chances for the hearsay to be admitted, then have that in a writing. So let me give you an example to illustrate what exactly hearsay is, rather than just define it. and explain how it can actually be best used in your favor. So you have a dental problem and it's, minor dental malpractice. Your dentist should have done this. He did this instead, and this is why you have the damages that you are suing the negligent defendant dentist for. So what you can do is go to another dentist, ideally two, but that's not really practical. Go to at least one and ask them if they would put their findings in writing, their diagnosis in writing. Now, they're probably not going to do this at all. They're definitely not going to do this for free, most likely, unless you have a really good dentist who you've known for a long time. But ask that dentist, here, look at what happened. This is not something that I think is normal. I'd like to get your opinion. And then the dentist will write his or her opinion down, hopefully on a piece of paper, which you can admit, and that can usually overcome the burden of hearsay if it's on the letterhead from the dentist, signed by the dentist, better yet, has a dentist license number. And that really boosts you over the threshold to show there was professional negligence. Because who are you to tell the judge that this professional that you're suing was not performing to the professional standard of care? Unless you are a licensed dentist yourself, your opinion doesn't matter, but another dentist's opinion does. All right, so in addition to being conclusory, starting with the conclusion, getting right to, as they say in the military, the bottom line up front, the bluff. Another thing you can practice is answering the question, what did the defendant do wrong? You should be able to answer this as succinctly and clearly as you can, and rehearse and revise your answer at least 5 to 10 times until there's nothing left that you can take away and there's nothing more that needs to be added. Next, you want to gather the most compelling exhibits and evidence that will substantiate your claim, especially the initial claim that you're going to lead with. So if you can't provide any evidence to your claim, don't make the claim. Now, if it's really important to make the allegation, you have no written evidence, well, then you don't really have a choice. But what most litigants do is they don't adequately prepare. They either don't prepare at all, or they prepare in the wrong way and they dump too much extraneous, irrelevant information. Sometimes these exhibits are over 100 pages, and you expect a judge, a commissioner, or a pro tem to spend more than just a few minutes reviewing your case before the hearing. They're gonna read this in his or her chambers, and they're gonna make an impromptu decision, not impromptu in the sense that it's regardless of the law or the evidence, but it's based on the best evidence that they can find that's presented at the time. So you have the judge's attention for a fleeting few moments. If you are going to waste those moments talking about things that aren't immediately relevant and helpful to your case, then you are wasting not just the judge's time, not just the court's time, but your time, and wasting your potential to prevail. And then what can your corroboration consist of? So if your small claims dispute concerns the breach of a contract or breach of another written promise, then obviously you not only want to lead with the exhibit that illustrates what the promise was and how it was later breached, but you also want to have the contract tabbed and highlighted to point to your rushed and impatient judge exactly what the key term was that the defendant breached, which led you here today. So organize yourself so you can help the judge help you. And my final tip is to use a 3-ring binder, even if you've submitted your exhibits electronically. So you have the option in most jurisdictions, not all, but like in San Diego, for example, you can submit your exhibits electronically, entirely electronically. And you can and should submit them at least 10 court days prior to your hearing. So when you've done that, you still want to have all of your exhibits tabbed and organized for you to locate at trial, because you want to be able to see what the judge sees, and you want the judge to be able to see what you are looking at and what you want the judge to see. The best way I've found to do that is to start with an oversized 3-ring binder. Just get it larger than you think you're going to need. It's better to have the extra space for extra pages than to cram everything in and have it not close. And you want tabbed sheet dividers, so the sheet spacers. You also want sheet protectors, and you want each exhibit to have a cover page in front of it that says Exhibit A, Exhibit B, Exhibit C. And if you can, give it a description on that cover page, that's even better. Just, a 2 to 4 word summary of what that exhibit is. And start with the most important ones first. Because remember, you should basically work backwards. Start with the conclusion, start with what is most important to your case before you go into the extraneous details. The judge is going to ask you if there is missing context, and then you can start to answer those questions. But what a lot of litigants do is they answer so many questions that were never asked. They, in their mind, think, well, the judge will probably want to know this, so I better tell him, even though the judge hasn't asked. I bet the judge would want to know how I met my landlord. It's a funny story, right? No, the judge doesn't care unless it's absolutely relevant. The judge first cares with what the allegation of breach is, what evidence do you have to substantiate that there was a contract or covenant, and then what evidence do you have to show that the other party did not comply as you say. And there are secondary or tertiary concerns that flow after that, but start with the most important aspects first. Now, if it is relevant, such as, this is my landlord, but he's also my uncle, so this is why, corners were cut, strings, were left hanging, we have a lot of holes in this agreement. That might be relevant, but most of the time you need to decide whether bringing in, familial dynamics or relationships, or why you got that job in the first place, how long you've been wanting to work there, how long you've worked there, all that stuff that people love to talk about, over casual banter is not appropriate for the very time-constrained nature of a small claims hearing. Now, it might seem like I'm going overkill and overboard on something like a small claims matter, but that's how I am with almost everything, especially ask my wife. Right. I always assume things will turn out terribly, so I prepare for that eventuality, and then when I'm wrong, I'm happy. Versus if I were to be the opposite and assume things will probably work out just fine, and then I find myself unprepared for something that I should have prepared for, could have prepared for, and could have foreseen, then I have no excuse and I have no one to blame but myself. So that mentality has served me. I hope it might help you, especially if you're someone who likes to procrastinate or slack. Use this as a lesson to prepare you for things that are more serious in life than your small claims hearing. And I hope you found value in this video. Please let me know if you did. Let me know what I can do to improve. Thanks for watching.